Good evening, everybody. Hope everyone is doing well. So, what's new? Anything exciting going on in the world? Um, Obviously, there is a lot of stuff going on. Up, we just had the dog come in too. That's how exciting the world is. Um, Obviously, one of the questions I've been getting a lot by email is what is the impact of the election on Social Security disability? And I think it's kind of early to really say. What I can tell you is um, that Commissioner O'Malley, who was appointed as there was an acting commissioner. Um, Long story short is I believe the commissioner has a 6-year term that is not, subject to termination by the president. Um, but Commissioner O'Malley filled the I guess the remaining term of Trump's last appointee, and essentially there was an acting commissioner. He filled it. His term ends January, I think January 19th of 2025. So as a practical matter, Commissioner O'Malley is going to be out. That is not a good thing. He's been a very, very good commissioner. He's really made an effort to try to deal with the backlog and really help people who are applying for disability, treating it like trying to get the bureaucracy in motion. He's had a difficult time, as he acknowledges. He doesn't have enough money allocated to hire the people, but you have a good administrator who's going to be gone. Who comes next? Who knows? The gentleman that Trump had appointed last time was a fellow named Andrew Saul. Mr. Saul didn't really have any experience in Social Security, and he was not very popular among Social Security employees. The big difference here is, and I read this in an article, just a blog post I was looking at, is that if you look at the people who voted for Trump this time around, it was a lot more working people. Obviously, a lot of Hispanic folks. And so the people that voted for him are people that are more likely to either need to apply for disability or have relatives who apply for disability. So one commentator made the point that this is probably not a constituency that he wants to alienate. Whether that's true or not, I have no idea. We just don't know. I will also tell you that when Trump's last commissioner, Mr. Saul, was in office, there was kind of I don't know how I would even call it, but there seemed to be an effort by Social Security judges in particular to increase the approval rates. Seems like there was some hostility coming from the higher ups, and so the judges kind of took it upon themselves to increase the approval rates. And in fact, the approval rates did increase. Bottom line is, I don't know. I think it's really too early to tell. We'll just have to see. I mean, I've been doing this a long time, and I've seen commissioners appointed by Republicans and Democrats. I can't tell you there's been, okay, enough here. I can't tell you there's been a huge difference. I mean, O'Malley's the first one that I've ever seen who really seems to know what he's doing. So hopefully we'll get somebody in there who has a clue and doesn't have any kind of a bias against it, against Social Security. Obviously, for Social Security retirement, they call it the third rail of politics. Politicians don't want to deal with it. It's going to run out of money at some point. Whether they just kick the can down the road, who knows? Only thing I would tell you is if you are, thinking about applying, given that if they make changes, they will do so typically going forward. So, that what they would do is, for example, one of the things that's been floated in past years is let's eliminate the 1 year, look back as far as payments on SSDI cases, retro payments, and let's make it 6 months. Never went anywhere. But when that came down, the thought was that would apply to people who applied after a certain date. So my feeling is if you're thinking about applying or have someone in your family who's thinking about applying, probably better to do it before January. That way you're kind of grandfathered in for the old rules. Again, doesn't mean they couldn't change that, but that's just my thought. So that would be my take. I think it's just too early to know. I looked at both Trump's and Harris's websites for discussion of Social Security, and really all they both said was, we will strengthen Social Security. We have an, unalienable bond with our seniors, and we're not going to mess with Social Security. But of course, that doesn't mean anything. So both of them said that. What Mr. Trump will do, I don't know. It appears that he's got control of the House and the Senate. So, there could be some changes. But we'll just have to see. We'll just have to see. I don't know. Obviously, we're going to keep an eye on that. As more people, as things come out, I'll let you know in future, in future of these live streams. But right now, there's just not enough to say. So again, Prepper Joe had asked this question. As far as will they increase the number of CDRs, I think that's probably not an unreasonable thought. They might increase the number of continuing disability reviews to try to purge the roles. That certainly could happen, but again, we just don't know at this point. Will they try to get rid of SSI? I doubt it. I think that, SSI is a real safety net program for people who are, have very low income and no earnings credits or not enough earnings credits for SSDI. They have not increased the limits in terms of what you can own or what you can earn in years. I mean, it's absurdly low. I think it's $2,000 of assets. I would not look for that to go up. So I think that's probably not going to go anywhere. So again, SSI is not going to be, upgraded in any way, shape, or form, I don't think. But other than that, I don't know. Okay, Shannon from Budapest, which is apparently early in the morning in Budapest. And I've heard it's a beautiful place. Never been there. Hopefully one day. And she wants to know about CDRs handled for recipients overseas. I don't think there's a lot of difference. The big difference is they send you the form, the short form or the long form, but apparently there is a provision that they can request that you come back to the U.S. For either an exam or for a meeting. That's what I've read. So again, I think that if you're going to the doctor, continue to go to the doctor so you have medical records that would support your case. And, if they send you a form, obviously fill it out. You want to make sure you're getting your mail properly, whether it's a U.S. address and it's forwarded to you or if it's going overseas, and to make sure you get it, but you want to respond to it. But I think that there's an article on let me see if I can find it real quick. Yeah, on the Huntington's disease website, it just says, you may have to return to the U.S. To review your SSDI eligibility in person because your case, could continue to be reviewed. So that to me would be the biggest problem would be you'd have to pay for a plane ticket to come back to the U.S. Now, obviously, Social Security has gone to virtual telephone or video hearings. Would they allow you to do a video meeting with them? Possibly, I don't know. But I just think it's really the same concept as, does your medical record continue to support, that you meet the standards for disability. Okay. Kim Dyer says hello. Hello, Kim. And James McHugh says hello, Sadie. Hello, Sadie. Sadie is kind of getting just kind of hanging out here. He likes to hang out with me, so she comes onto my office most days and just kind of hangs with me. Okay, Terry Clemens. Can you tell me about a remand case back to the ALJ from the Appeals Council? The ALJ didn't get my doctor's RFC reports. I've got 3 doctoral reports. Okay, so what Terry's asking is he went to a hearing, got an unfavorable decision from the ALJ, Administrative Law Judge. He appealed it to the Appeals Council. That's the next level up. And the Appeals Council can either grant the case, which is very, very rare, or they can remand, which means send it back to the ALJ. The problem is they send it back to the same ALJ that denied you. I don't know why it makes no sense, but that's what they do. So now the ALJ has been given instructions to consider additional evidence. And what I see this a lot in my remands is, the judge did not explain why he was not giving any weight to a particular doctor's opinion, or he didn't discuss it and really didn't include it in his functional capacity question. So the Appeals Council says, Judge, you need to look at this medical report and you need to consider it and discuss, how you considered it on the record. And, I've said this before, I think a lot of times when an ALJ gets a remand, the underlying message is, we took this case as a remand because we think you screwed up, judge. Go ahead and approve it. Some judges pick up on that, some don't. But I think that, that's something that's not uncommon for a judge to sort of pick up on the hint from the appeals counsel. But yeah, the judge will need to look at those other records that were not thoroughly considered. And so if you've got strong records from RFC, or residual functional capacity, or I call them functional capacity forms from 3 doctors, the judge is going to have to explain why those are not given weight, and why he's not considering those. And, again, there's a lot of rules at the appeals council about, what the judge has to do. But I think, generally speaking, if there's evidence that the judge is ignoring, he needs to explain why he's ignoring it. Kim had a hearing today. The vocational witness said unable to do past work, and none in the economy. That's great. That's what you want. So you probably have heard of something called the 5-step sequential evaluation process, which is kind of a very complicated way for Social Security to look at cases. And just so you know what they are, step 1 is, are you working? If you're working at SGA level, which is $1,550 in 2024, I think it's $1,620 and 25. But if you're earning less than $1,550, you're not working for their purposes. Step 1. Step 2 is, do you have a severe impairment? And really, that's what that means, is, do you have an impairment that is worthy of medical treatment that's been diagnosed? It's not a real high standard, but you got to get through that. And I've seen judges, basically turn cases down on a step 2 analysis by saying there was nothing here severe enough to even, get to the point of we're looking at how it impacted work capacity. Nothing firmly diagnosed. Question 3 is, do you meet a listing? Very, very hard to meet a listing, but that's question 3. Question 4 is, can you return to past relevant work? Which, again, if you can't do your past work and the medical record supports that, then the burden of proof shifts to Social Security to prove at step 5 there's no work you could do. So when a judge asks hypothetical questions, first the judge will say, can you go to past relevant work? No. Next step is, are there any other jobs that exist in the economy? And if so, name them. That's because Social Security has to prove it. If the VE said no jobs, then you probably won. Now, let me say this, because I've listened to hearings, I've talked to people who said to me, the vocational witness said there was no jobs I could do, but the judge denied me. So I listened to the hearing report, or the hearing tape, or the audio, and lo and behold, I listened to the questions. The judge asked the vocational witness 3 questions. One of them, included a lot of limitations and yielded the result there's no jobs that exist. But 2 of them, there were jobs. So, you got to really think closely, Kim, was there any question at all that the vocational witness said that there were jobs? Maybe not. Let's hope not. But, sometimes people don't hear those other questions, and they misrepresent, not intentionally, what happened at the hearing. But I think that, and that's why, by the way, it's not a bad idea to ask your lawyer for a copy of the hearing audio, just so you can listen to it, because, I listen to mine sometimes, and it's incredible what I'll pick up, stuff that I really didn't even remember happening at the hearing. And lo and behold, I picked it, listen to the hearing record, and there's something that went on that, I use in future hearings. So not a bad idea to listen to it. But if in fact the judge, asked questions of the VE, the vocational expert, and there was no jobs available based on that hypothetical, which is really, the judge's interpretation of your RFC, your residual functional capacity, then that's a pretty good chance that you win. Okay. Yeah, the appeals. This is Terry's with the appeals counsel, and his point was that the appeals counsel gives instruction back to the judge. So that's pretty common, and that's where the judge has kind of been given direction about what he or she needs to do. Vince, how are you doing? One of my clients. How are you doing, Vince? Hope you're doing well. St. Louis Grant, another regular. Can you talk through the rules around adding information or evidence to the file if and after the ALJ denial before an appeal, the appeals council? Generally speaking, after the ALJ hearing, the record closes. I think that if there is evidence that existed but was not available, you can submit it to the appeals council. But the appeals council is typically working with a record. They're not looking at this case as a new evaluation or reevaluation. They're simply looking at what happened. Did, as in Terry's case, did the judge, use the proper steps in interpreting the evidence? Did the judge, consider subjective complaints? Did the judge, there was medical evidence from a treating doctor that identified certain limitations? Did the judge consider that? And if he didn't, why not? So really, the appeals council is not the best place to submit new evidence. That being said, if there is evidence, let's say, I'll give you kind of a crazy example, but let's just say that there was a surgery that you underwent, a herniated disc surgery, that for whatever reason did not make it in the file. And we've got this whole 5-day rule now where you've got to get the attorney is supposed to make the record complete. But let's just say, for sake of argument, that the hospital or the doctor that provided or did the surgery was simply uncooperative, or the records were there was a fire at the hospital and the records were not available at that time. Now they're available. They existed, but they were not available for some reason beyond anyone's control. I think you could submit that. But I think that, it's going to be an uphill battle to expect the appeals council to really look at the substantive, evidence again. They're going to look at the record as it was when the record was closed. In fact, when you go to a hearing, the judge, there's the 5-day rule, which basically says we're supposed to have all medical evidence in the file within 5 business days, 7 to 8 calendar days, but 5 business days prior to the hearing. And if you don't have it in, the judge is not obligated to accept it in. So I've had judges, basically, I've had people tell me, we're pretty good about making sure the record's complete, but I've had judges basically say, I've heard audio and I've heard it from other people that judges like, I'm not letting it in because it wasn't provided within 5 days, and I'm not going to look at evidence that was given to me the day of the hearing. So some judges are a little more lenient about that. Some are like very hard line. Personally, I think that I understand the reason for the 5-day rule, and I think that if a lawyer or a claimant shows up with 500 pages of records, I could see a judge being very reluctant to want to consider that and to have to because it's a lot of work for them. They've got to now go through this. They've already prepared the case. They've got who knows how many more cases that month, 15, 20 cases left in the month. And now they've got to go back, look at 500 pages of new records, and then come out, then refamiliarize themselves with the case. That's asking a lot. But if it's a 2 or 3 page note, a recent, medical record from an office visit, it's going to take 2 minutes to read it. I don't think that, to me, in my opinion, that shouldn't be something that a judge, would refuse to do. I mean, if I was a judge, again, I wouldn't be real happy about 500 pages. And what I would probably do was I would give the attorney and the claimant, again, if I was a judge, I'd say, look, I'm not going to read this. This is inconvenient for me. I'm happy to reschedule your hearing, and we can come back in 4 or 5 months, and I'll have a chance to read it. And if you don't want to do that, then I'm not going to consider it. That's what I would do. But again, judges are going to do their own thing. And some of them, it's a power thing, so they want to throw their weight around a little bit. But so bottom line is, yes, you can submit new stuff to the appeals council, but it's pretty difficult. It's got to be very, very specific circumstances, and that's really not the best place to do it, in my opinion. Okay, Eunice Saleh, hope I pronounce it right, Eunice. 53 years old, and I've been pain in your back for some time, but recently the 4th and 5th vertebra been hurting me a lot. And I suspect your question is, here we go. I guess your question, here we go. What are your chances to win? I think the big question here is what exactly is going on with your back? I think that, the MRI is kind of the gold standard for evaluating spinal issues. So, you may have pain, but the question is there some sort of a disc issue? Is there a spinal cord issue? Realize back pain can be caused by musculature, just a strain or something. It can be caused by, there can be pain that's associated with a bulging disc. There can be pain associated with a herniated disc and severe nerve root compression. Generally speaking, and again, keep this in mind, back pain is the number one reason people file for disability. So if you're pursuing disability based on back pain, you really need to have objective evidence documenting something in your back, a disc involvement, spinal cord involvement that is severe enough to be consistent with the level of pain you're describing. I've looked at MRIs. People sometimes send me an MRI and it'll say, spondylosis, which is degenerative disc disease, mildly bulging disc at L3-4 with no, spinal cord impingement, no stenosis. The person's saying, I can barely stand the pain. I'm in just excruciating pain 24/7. Not consistent. And the judge is going to look at that and say, well, there's no reason that that someone with a mild disc bulge, which a lot of us have, would have excruciating work preclusive pain, and they'll conclude that you're exaggerating your level of pain. So I think there needs to be an objective test with back pain that shows something significant enough to account for the level of pain you're describing. And if there's not, it's going to be a real uphill battle to convince the judge. It does help that you're 53 because you can look at the grid rules. And again, the grid rules at 53 would basically say that you could be found disabled even if you could do sit-down work, because there's not a lot of sit-down work jobs for a 53-year-old with a bad back. So, it gives you a little bit of a modified definition of disability. So all you have to prove is that you can't do light work or basically that, sedentary work, even if you can do it, you're still disabled. And you don't have to prove that you can't do anything, just have to prove that you're limited to sedentary work or a more strenuous type of work, and you could win. But I think you've got to have MRI, CT, some sort of objective test units to have a real good shot at that. Charlene, I'm on SSDI, okay? I'm in the EPE stage. Not sure what EPE stands for. I might get a job I had before receiving SSDI, a low-skill job. I was okay to do so. I think that you're 60 years old. I think that, Charlene, the real question is how much you're going to be earning. So, you have the 9-month trial work period. So that's one thing. And you can earn in 2024, 1,110. I think it goes to maybe 1,150 or something going forward. But let's say you can use up your 9 trial work period months. Then, as long as you're under SGA, 1,550, again, I think it's 1,620 next year. As long as you're under SGA, not a problem. The issue you run into is if you use up all your trial work period months and then you start working and you're over SGA, then you're going to have a problem because you're going to get into overpay status. So I think you need to really look at your earnings, by the month, by the date you receive them. Again, let's say you work in November, you get paid in December, that counts towards December. And they look at it literally calendar month to calendar month. So how much did you earn in November 24, December 24, January 25? What were your earnings looking like? Gross earnings. And you can, if you have expenses that you needed to incur to help you work to account for your disability, maybe a special monitor or some sort of a stool or something like that, you can take that off the top if you have to rent that. But generally speaking, they're looking at gross income, and the question they're going to ask is how much your gross income was, whatever you were doing. And I think certainly if it's an unskilled, very low skilled job, that's going to be more in line with a person who has pain that makes it hard for them to focus and concentrate. So yes, you can work, but you want to keep a month by month tally of your receipts and the gross income you received. Kelly, you mentioned Dr. Dave Foster during your lives. He mentioned that he would welcome a collab with disability law. Would you consider? Yeah, absolutely. I'll reach out to Dave. Yeah, he would be a good person to have on here, because I think he deals with consultative evaluations, and I get a lot of questions about that. And he and I have spoken, we've corresponded, and he, like I said, he's one of the few, in my opinion, that really does it right. So yeah, that's a good point, Kelly. I'll reach out to Dave and see if we can get him on next couple of weeks, and I'm sure people have some questions for him because again, he's looking at it from the medical standpoint, and he might give us some tips about how to best proceed with your consultative evaluations. Hello, Donna. How are you doing? I hope well. Jonathan Logan. Anything specific to say to the judge when you go from mental issues, anxiety, depression, fatty liver disease, Meniere's disease, all these together, hemochromatosis. So, I think that when I have a case, and I've got a case tomorrow and on Friday with people that have both physical and mental health conditions. My general approach is let's start with the physical condition because that's something that could be more objectively determinable. Fatty liver disease, which is not uncommon, but what does that mean in terms of your symptoms? Do you have to use the restroom a lot? Do you have any kind of pain? Do you have fatigue, weakness, things like that? The Meniere's disease, do you have balance issues? How often, how severe it would be? What kind of evidence do you have to document that you've really got it? So I think if you start with the physical side of things, then you can go through the objective evidence, and then the mental part of it, typically is going to be something that just adds to the mix. Now, my opinion, and this is just me, that if I'm pursuing disability on behalf of a person with mental health problems, I'm looking for what I would call indicia of severity. And what I mean by that is that, mental health, back pain is the most common reason people file for disability. Depression, anxiety, PTSD is probably the second reason people file for disability. So if you have, depression, anxiety, PTSD is an anxiety disorder, by the way, or any kind of mental health problem, then what are the judges looking for it to be serious enough, severe enough to disable you? They're looking for things like multiple inpatient hospitalizations. You were so bad off that you had to be hospitalized, maybe even against your will, or even if you went and you were hospitalized for 2 or 3 weeks because you were so unstable. You have doctors, a treating psychiatrist who puts you on medicine A, it didn't work, you increased the dosage, didn't work, put you on medicine B. Sort of just a series of failed efforts to control your symptoms, with medication. Maybe it worked for a short period of time, but then it stopped working. So that's another indicia of severity. I think having, ongoing treatment from a psychologist and a psychiatrist, that shows there's, both, there's a significant, organic problem that requires the services and treatment from an MD, that would be the psychiatrist, where he's giving you medications. But yeah, and the counseling shows that you're just having this ongoing issues trying to deal with whatever the issues, the depression, anxiety, whatever the situation might be. But that, they call it longitudinal treatment, ongoing treatment record would be something that the judges typically look for. And if you're going to your family doctor and you're getting, Zoloft, that's probably not going to be enough. It's going to need to really be a specialist. Another indicia of severity would be suicide attempts. Not that, obviously, this is not something positive at all. Sorry about that. I think my wife just came home. And suicide attempts really would indicate a really severe mental health problem. So that's the sort of thing. So if you don't have it at that level, but you still have it where, you've got significant problems. Like I have a case coming up on Friday, my client, there's indication in the record that she has a real difficulty dealing with authority. She's very, gets angry with authority figures, loses her cool very easily, doesn't interact well with other people, becomes very distracted, would not be able to meet, we have a record that says not be able to meet production norms. That's a pretty significant problem. But on its own, mental health cases, you have to have a severe level of impairment, and it's got to be something that would, clearly result in uh, problems performing a job, being reliable at a job. I think if you've got physical problems and mental health, you sort of, you kind of talk about the cumulative effect. And when I do my brief, I'll typically talk about the physical problems, and then I'll say, in addition to these physical issues, which limit the person to, sitting for X number of time, standing for X number of time, my client has significant mental health issues that, limit her ability to interact with coworkers, supervisors, or the public. She's PTSD is triggered by loud noises or smells, or certain types of voices, and just kind of go through it that way. But I think that, generally speaking, unless you've got really, really significant mental health issues, just treatment-resistant depression, where a person is really not able to handle, just just their daily life. The physical stuff I usually go with first, but that's, you try to argue cumulative effect, combined effect under a functional capacity theory. Sure, Prepper had a question about what's the impact of Trump presidency, and again, we don't know quite yet. All right, Mark is in Georgia. Well, I'm in Atlanta, and draws disability if you move out of state. Yes, stays the same. It's federal. Stays exactly the same. Okay, beautiful light. Jamil, beautiful light. Young adult, injured at work in May. March, got into a bad car accident. Too much pressure. Mentally, I couldn't function. I started getting time off of work until I finally quit. Line for disability for me with my therapist, magnetized anxiety depression. I work since July. Okay, here are the issues that we were into. Number one, you say you're a young adult. I'm assuming you're in your 30s. Always a major uphill battle. Very, very hard to win disability in your 30s, 20s, 30s, early 40s. They just don't want to approve it. So I think that that's going to be a big problem. Second thing is, anxiety, depression, as I just talked about, it's got to be at a really, really, really severe level. You didn't talk about any other physical issues going on, but if it's all mental, I'll refer you back to what I was just talking about, the indicia of severity. That's kind of what you've got to have. And again, keeping in mind that if you're under 50, it's more of an uphill battle. Another comment I would make, if you're on workers' comp typically offsets Social Security dollar for dollar. So as long as you're receiving temporary total disability benefits in comp, you're not going to be able to get Social Security. Therefore, you're not going to find an attorney to take your case, because we get paid a percentage of past due benefits. Well, every month you're getting past due benefits that you'd be getting them if you're getting workers' comp, offset. No money, no past due benefits. So, I've had people that have great cases, Social Security wise, great, significant medical issues, but they're getting comp and they plan to be on comp for the next 2 or 3 years. I win the battle but lose the war. There's no fee for it. I can't stay in business working for free. So that's going to be the bigger issue. But I think your youth is going to be probably a bigger problem. Okay. I'm a 52-year-old firefighter, been in the job 25 years. Well, thank you for your service. I've known several firemen over the years, and again, we don't pay them enough. We don't express our gratitude enough, because goodness knows if you need a firefighter, you need it's very specialized skills. So thank you for what you have been doing. PTSD, which is certainly understandable. Will retire in 2 years, receive SSI after 6 months of not. You don't need to wait 6 months of not working. It's called the 6-month waiting period for getting benefits, but you could file for disability the day after you stop working. I think this is going to come down to degree. PTSD, realize the grid rules do not apply to mental health problems, only apply to physical problems. So let's assume you are, 53, 54, and you can't work, and you say, I've got terrible PTSD. Well, the first question that a judge is going to ask is, are there simple, low-stress, entry-level jobs, a packing job, a marking job, an inspection job that you could do that would not trigger the PTSD? So you're going to have to show, if this is your main impairment, you can't do any job at all. and no matter how old you are, because grids don't apply because it's not physical. So, let's assume you cannot go back to doing a firefighting job. Very stressful, very, triggering of PTSD. But there are a lot of other jobs that are not nearly as physically or emotionally demanding. You've got to have a level of PTSD that would preclude even those. And, not being able to, if you look at the forms, they talk about not being able to handle work stressors is an example of what they talk about. So it's got to be to the point where, doing any kind of work, keeping any kind of schedule, dealing with work pressure, it just doesn't exist. And you're going to need a treating doctor, typically a psychologist, psychiatrist, to essentially say that. Terry has the case with the appeal. Why do I have two appeals counsel sign off my remand case? A lot of people have one. I think what you're saying is that the more than one judge signed off on it. They do that sometimes because the appeals council, I think there's a 3-judge panel that looks at them, and if 2 of them happen to sign it, that's just the way it is. I don't know. Although again, maybe this is a situation where the judges are saying to the ALJ, this is a case that should be approved, and we're both saying that. So that's probably a positive sign for you. Jen from Nebraska, my paralegal. Hello, everybody. Hello, Jen. Let's see. Kim says, thank you. You're welcome, Kim. Official payday. Got it. I was found fully favorable SSI is not automatically eligible for SSDI. No, SSI and SSDI use the same standard, the same definition of disability, but SSI is a means-tested, I'll call it welfare program. Basically, if you don't have enough credits for SSDI, you can go SSI. The problem with SSI is there's something called the deeming rules. And so if you have, let's say, a spouse that's earning $50,000, $75,000 a year, your spouse's income will be deemed to you. It's assumed that you can have access to it. You have an asset limit. I think it's $2,000. So, you can qualify for SSI medically, but not qualify non-medically. But if you don't have the credits, so the reason if you file for SSI, you don't have enough earnings credits, you haven't worked in 10, 12 years, you're not going to get SSDI. SSDI, you have to have not only the disability part of it, you've got to be disabled medically, but you have to have enough earnings credit. You can go to ssa.gov/myaccount. You can download your statement. It'll tell you if you have enough credits. But it doesn't, medically it would automatically qualify you, but not on the non-medical requirements. Okay, Steve received a BA with a major in history. I did too. That's actually was my major. Other than teaching or being a lawyer, not much that a history major will do. Mine was actually in British history in the 1920s and 30s. I know that sounds really exciting. I happen to have a really, really good professor who is my advisor, who actually we've been friends, since I graduated many, many years ago, and that was his area of specialty. And so I kind of just went with it, knowing I wasn't going to be a professor. I was going to go for law school. But the interesting thing about history is you really delve into a particular era, and you learn about kind of not just the stuff, the highlights, the headlines, but you kind of learn more about people's lives, what it was all about. You look at different sources, newspapers, diaries. It's really, you go way beyond what you might read in a paragraph in an encyclopedia or even a history book. You go way beyond that. So history majors, it's actually a good way to kind of prepare for law school, because you have to sort of dig a little bit and not necessarily take things at face value. So again, I was a history major. So Steve, I'm sure you know what I'm talking about. Entertainment tech for 40 years. Bad back with the grid rules treat you kindly. My opinion is that education has rarely been a problem with the grid rules. If you look at them, they talk about high school education or more. So whether you have a high school education or you have a 4-year degree or you have a master's degree or more than that, if you have medical problems that prevent you from focusing and concentrating, or making a direct entry into skilled work, it's not going to be an issue. And I think, as you correctly point out, you had a history major in college, 40 years ago. So, realistically, that college degree, what practical value is, something you did 40 years ago? The look back for jobs now is 5 years. So are they going to assume that, because you're a history major 40 years ago, that you have some specialized knowledge or skill? Do you have intelligence? Yes, you went to college and got a major in history. But, I don't see them, in my opinion, my experience, judges don't really treat a college graduate any different than they do a person who is a high school graduate. And the grid rules do not really make any distinction between a college graduate and a high school graduate. So, in my opinion, it wouldn't be a big deal. Christina, a loyal viewer. Hey, Christina from California, how are you doing? Brian Matola, is it normal that your lawyer gets paid before you do in back pay? He got paid in August. I don't assume my back pay. It is not uncommon. And sometimes the reason is if you have a concurrent case, SSDI and SSI, Social Security has to do, they do a couple, for the SSDI part, they've got to look to see, do you have any earnings after onset to see whether or not there's any kind of an SGA problem, substantial gainful activity problem. If you have an SSI part of your case, they've got to do more thorough income and resource interview that can take a few months. So it's not that uncommon. Usually they'll cut the checks around the same time, but I have a few cases where I've gotten paid. My clients, have to wait several more months. So it does happen. Not that usual, but it's certainly, if you have not been paid, it might make sense for your lawyer to find out what's going on, what the holdup is. Where can I find the information about the ALJ that will do my hearing? I will show you what I use. Give me 1 second here. I use the Atticus website. I'm going to put that in the comments here. It is from 2022, so it's a couple years old, but I think that it's still valid. And there's other places you can type in approval rates for Social Security disability judges. But if you go to the Atticus, and let me just share my screen so you can see it. Here's what it looks like. This is what I look at. I just do a Control F and search, and I look at the judge. What I also do is I participate in a listserv with other disability lawyers. And so very common, people ask in the listserv, have you had Judge Smith? Have you had Judge Jones? And people will share their comments on it. And what I do is I use a case management program called My Case. And we, let's say we have a case and we have the judge and we have doctors and whatever, I will keep notes about the different judges that I've appeared in front of. They ask for an opening. Are they pleasant? Are they trying to trick my client? Are they mean? What are they all about? And then if there's another, I'll do a search in my email on the listserv to see, has anybody else had that judge? So, and I've had situations where I will call another attorney. I've got a case coming up in November, a couple of weeks with a judge out of Savannah, Georgia. And I don't know the judge, so I called a colleague of mine in South Georgia, and she was nice enough to send me a printout of the questions that this judge asks, which I've provided to my client. That's going to be what she and I, will be talking about in our pre-hearing. But yeah, you can do a little research. You can just type in approval rates for Social Security disability judges. If you have a lawyer who's part of NOSCR, the NOSCR listserv, there's a lot of good information there about different judges. And, like I said, if it's somebody, if it's in a jurisdiction that I know somebody, I'll call them up. Or even if I don't know them, I may just reach out to the lawyer and say, hey, if I see they're a fellow member of NOSCR, I'll say, I got Judge Smith coming up in a couple of weeks. What can you tell me? And usually people are pretty open to that. I do that. People ask about judges in the Atlanta area, that if I know them, I'll tell them. Or if it's a judge even not in Atlanta, I'll still tell them if I know them. Jonathan L. I have anxiety, depression, Meniere's. I think we, okay, I think this is, thinking this is the one you had reached out or you had a question before. Um, you went in front of the judge. She said you could work 5 days a week, 40 hours, applied again, what to say. Um, and you raised, Jonathan, a very good question. A very good point is if you reapply after an unfavorable decision, number one, they're going to look at the evidence as of the day after the unfavorable decision. Because, if you don't successfully appeal it, that unfavorable decision becomes a thing decided through the date of the decision. So, if you lost the first time, you're going to need something new, not about what to say. You're going to need new evidence. And that means you may have to go back to your psychiatrist or psychologist or your liver doctor or any specialist you're dealing with and see if you can get a functional capacity evaluation, see if you can get a letter that explains why things are different now and why they're really serious to the point where you're not able to work. It is an uphill battle, Jonathan, I will tell you, to win a case when you've been previously denied. You are 38 years old. Going to a different judge, that's a good thing, but 38 is really very, very young. How long would it take to file a claim with me? Well, again, I tell my clients, if you want to go ahead and file it on your own, and you want to do that, and hopefully you can avoid paying an attorney's fee. Although again, we don't get paid the first 5 months of disability, of past due benefits, called the 5-month waiting period. Nobody gets paid. I'm usually able to get these cases filed. I'll walk you through what we do. Somebody calls me and says, I want you to file my application. I then send them a link to a questionnaire that really tracks the application, question for question. And there's a lot of ridiculous questions in the application. They want to know about prior marriages and the date of birth of a prior spouse and where you went to high school and all this stuff. And then, of course, the medical information there. So once somebody's filled that out, I have a paralegal in the Florida Panhandle. As a matter of fact, she is the daughter of my paralegal from many, many years ago. And her name is Stephanie. And Stephanie will draft up an application. It comes back to me, usually 3 or 4 days later. I review it, make changes. If my client wants me to, I'll go over it with the client. Otherwise, I'll just file it. So we can get cases filed in, usually within a week or so. But if you're in a hurry, go ahead and file yourself. It's not that hard. Sometimes I will put in the remarks section, a reference to the grid rule or a listing or some argument. But generally speaking, it's just a matter of getting the information they want, to them in some sort of organized format. So if you ask, if you were to retain me, and you got everything together, we're looking at probably, a few days, but the whole process might take a week or 10 days before, you got the information to me and I got it into the right type of format. All right, Mark. Mark is one of my clients. How are you doing, Mark? Hope you're doing well today. Crystal, sclerosis, SI joint, dealing with forearm, lower back pain. It's going to be under the musculoskeletal listing, if you want to look at the listings, listing number 1. But no, it's not back pain per se, it's SI joint pain. If you are a surgical candidate, that is evidence of severity. And so I suspect that right now you're pretty uncomfortable, and that the level of pain would likely be enough to preclude, attention, focus, concentration at a job. Plus, you're probably not very mobile. You don't say how old you are. If you're over 50, that makes the grid rules really come into play. But if you're under 50, you've got to show that the level of severity of pain is really, really high, and having a doctor talk about that and saying you're really, you're at the level you need surgery, that can certainly be pretty compelling. Kevin, it's been 200 days to get a reconsideration. So you're saying you've been waiting 200 days. So you filed your recon and it's been 200 days. That's not that uncommon these days. So, you're going to, it could be, I've seen recons in Texas, for example, 13, 14, 15 months. It just depends. They're looking at it. They're requesting updated medical records. but there's no obligation by Social Security to get it done fast. Let's see. Tony says, I was approved back in July for SSA for medical, but they said I wasn't going to get back pay whenever I started receiving payments. So what may have happened, Tony, is that your onset date, either what you claimed or what the judge modified or Social Security modified it to, and I see this a lot, they'll approve a case, but they'll say, you didn't get disabled back in 2019. You got disabled in, October 2024. Cut out all the past due benefits. And so if your onset date was changed to a date, within 6 months of the current date, then there'll be no past due benefits because this 5-month waiting period, it's 6 full months. So the 5 full months plus any partial month, that may be why you're getting no payment. And then, once you're past that, then you should start getting monthly payments, assuming you are not found disabled for a closed period of time. So you want to really look closely at the payment letters they send you so you know. Okay. Thank you, Eunice. I appreciate your kind words. And on that note, I will put up here let's see here, where if you would like to leave me a review, please do so. That really helps me build my practice. So Eunice or anybody else, if you're so inclined, you can look up Ginsberg Law Offices on Google, leave a review there, or here there's a link there. You can leave me a review. It takes you to a review site. Stony Tony Truckin'. Got a letter from our primary care doctor saying I'm totally disabled. Will this greatly help? It will help, but it's better to have a letter from a specialist. I think judges take statements from primary care doctors with a little bit of grain of salt. Many times your primary care doctor, you may have some sort of a long-term relationship with that person. This is not a person trained in making disability evaluations. This is not a specialist. It certainly will not hurt. I've seen some judges rely on statements from GPs to grant, but my experience is most judges are looking for a specialist. If that's all you got, that's all you got. But, if you can get more, that would be helpful. Thank you, Charlene. I appreciate that. Neo Eclipse says, if your mental illness will make you miss more than 2 days a month, you're disabled. That is true. If you vocational witnesses ask a question, the hypothetical question says, our hypothetical person is likely to miss 2 or more days, really 1 more days of work per month unscheduled. Is that consistent with competitive work? And the answer is no. But you have to prove it. And so you would need a doctor, a psychiatrist or psychologist who would be willing to go on record to say that your symptoms get to the point where you would not be reliable at a job. You'd likely miss 2 or more days of work per month. And I would have my own functional capacity form, which I think I've mentioned. You can get those for free. Let me just put a link here as to where you can get one. But that would have that question on there: how many days of work you're likely to miss. So a judge is going to be looking, at treatment records as well as the conclusion by the doctor, and that would absolutely be something that would be very helpful to you in terms of winning. Okay. But yeah, your primary care doctor, less compelling than a specialist. Okay. MJ talks about measure. I'll go back to MJ's if I can find it here. I don't see again, major depression. I think we talked about the indicia of severity. Major depressive disorder is a fairly common problem, in the Social Security world. And by the way, major depressive disorder, that's a term of art. There's something that psychiatrists use called the DSM. And the DSM is Diagnostic Statistical Manual. And I think it's up to version 6 now, but it contains all the diagnoses that doctors use. And so major depressive disorder is a diagnosis. You see major, you think it's terrible, it's serious. You could have major depressive disorder mild without psychotic features, that might not be disabling. So just the term alone doesn't make you disabled. Ultimately, you have to have a psychologist or psychiatrist discuss the symptoms you've got that would make it really hard for you to work or impossible to work. Or, as Neo Eclipse says, miss more than 2 days of work a month. Can an SSI person rent a room and not be? I don't know. I want to say that it might count, but I would look at income and assets for SSI recipients, and it will kind of tell you what the requirements are, what you can and cannot do. I drink beer at a time. I'm not sure what that's all about. Okay. I now know how important, says Tammy, how an RFC can be. Never received one to complete. I thought I received and completed work history and pain one. Should I seek an RFC on my own? Thought I'm still waiting for initial app. Well, first of all, RFC stands for residual functional capacity. That is a legal determination that a judge would make. So we call them, many lawyers call functional capacity forms RFC forms because you're asking the doctor basically to sketch out an RFC for you. But technically, it's a functional capacity form. But yeah, if you have, I'll put this up again. If you can get one of those forms, if your lawyer can get it, great. If your lawyer is not able to do it or can't get it or won't do it, you can get your own. And I think these forms can be very helpful. Bear in mind, though, that if you get a form done, you've got to submit it. You can't leave it out if it doesn't come back helpful to you. So you want to make sure you kind of know what it's going to say before you submit it. Okay. Let's see here. Okay. 61 years old. Lulu's 61 years old and says, I paid into Social Security for 34 years. Now I have a back problem and anxiety, can't continue. I have all the doctor's reports and work settlement. So if the workers' comp case is settled, that's good. That would allow an attorney, to get involved. There needs to be something called Hartman language in that settlement, which basically says that this lump sum, $25,000, will be treated as if it was paid over your expected lifetime, which is another 35 years and equals to $65 a month. That would be the offset. So if you have workers' comp, in fact, I just did an article on my blog. Let me link that to you so you can see about workers' comp offsets, because I get that question a good bit. So let's just go here. Let me share my screen. Oops, hit canceled. Don't want to do that. Share screen. All right, so here is my website called ssdanswers.com. And then in the blog, which is over here, I wrote an article just this week about solving workers' compensation, the Social Security disability workers' comp problem. And really what I said there, you can read it, but what I said was, if your case is not yet settled and you're getting ongoing benefits, it's, there's going to be an offset, dollar for dollar. If you settle the case with Hartman language, it'll be a very minimal offset. But, you got to be aware that if you are having, workers' comp is involved, it's going to complicate your Social Security case. So it looks like you had a settlement, so you want to make sure there's Hartman language in it. You have back problems and anxiety. Again, it comes down to the degree. Back problems and anxiety can be mild, moderate, or severe. So what we need is to know how severe they are and what the doctor thinks it would do in terms of activities of daily living and other functioning. I put the wrong one. I was going to put the functional capacity forms. Put there. Oops. Let's see here. Okay. Case evaluation. Huh. That's interesting. I don't know why it's not. Let's hide that. Free case. Okay, there we go. That's just the ticker there. So yeah, if you want a free case evaluation, just go to that link, contact Jonathan 3. Happy to try to answer your questions. Okay, let's go back to the comments here. Let's see, TYS matrix. If I was with a closed period case, able to go back to work months later, disability symptoms recur, can't work again. Yes, you can reopen your claim. Absolutely. It will be expedited. You want it, but you have to call your Social Security office and tell me when to do it. Follow it up with a letter, but yes, you can. Lulu says, I went and had a medical exam by their doctor last Saturday. What's the next step? I would try to get a copy of it. I mean, ask your lawyer to log in and get your copy. That would be helpful. The next step is that Social Security, if they've not already done so, they'll continue to gather medical records from your doctors. And then they will get all those medical records together and the consultative doctor's report, and they'll give it to a medical consultant in-house at Social Security who will look at it and make a recommendation as to whether to approve or not. And that's what happens. And if they say not to approve, you can appeal it. You should appeal it. TIES matrix, 54 dizziness, imbalance, and fatigue due to benign brain tumor, seen with rest of the condition. I've had clients with brain tumors, non-cancerous brain tumors, and yeah, it can create a lot of functional issues. But I think what you're going to need is, make a list of all those issues and then go to your neurologist or the neurosurgeon and, try to get some support for the level, the brain tumor where you've got it would likely cause these symptoms, or even after surgery, it did not relieve them. But I think that's all in all, if you're having those kind of symptoms, you got, I think, a pretty good case. All right. Garrett says, hello, Jen, and hello, Christina. And Charlene is getting back to the person who was TIES matrix with a closed period. Yeah, you can ask in disability cases, SSDI, for an expenditure period of, actually it's extended period of eligibility, not expenditure, extended period of eligibility. I think it's 5 years, 3 years, 5 years, something like that. That after you're approved, if you go back to work and you can't work again within that 5 year period of time, now I'm thinking about the look and see, extended period of disability. It's 36 months. I stand corrected. So within the next 36 months after you stop collecting benefits, you can ask for an expedited renewal of them. But you have to do it by phone, and again with letter follow-up. Let's see. If I was approved for the closed period because I was able to go back to work, months later, disability symptoms recur to the point I cannot work again. Yes, again, you can reopen the claim. Yes. Let's see. TIES matrix on 54 with dizziness and balance, fatigue due to benign brain tumors, seem to improve this condition. Yeah, I've won cases on dizziness. I've won cases on imbalance. If you're 54, you're going to be limited, and you can't balance and you can't walk. You're limited to sedentary when you grid out. And if you've got, if you have look at this sedentary grids, the 201 series of grids, go to gridrules.net to see them. But yeah, if you can't work and you have a difficult time with focus and concentration, I think you've got a pretty good argument under the grids there. Let's see here. Okay, so Corlil Katana. I have not seen that one come through my desk yet. Let me just take a look here and see if it's here. It is not yet here. So Stephanie is likely working on it. We should probably have it done the next few days, next 2 or 3 days. Mark says, thanks. Christina says, extended period of disability. Extended. My question is about a major depressive order with tendency to wander off. Can you be a little more clear when you say wander off, meaning that you get really frustrated and depressed and just kind of take a walk and don't really have any particular place to go, and you may find yourself 10 miles away and, whatever. I mean, is that what you're talking about? I mean, give me a little more specificity when you say wandering off. Meathead, on the family. Recently applied for SSD. I have an exam 11/19. And you've got other conditions, GERD, plantar fasciitis, etc. The physical consultative evaluator is going to look at all those things. I mean, I suspect the back and the knee are probably more of a problem than plantar fasciitis, even GERD. You want to mention all those things, but I would look at the conditions. Think about the conditions that are most impactful to your ability to function in a work environment. And those are the ones I'd focus on. So maybe back and knee, it may be, GERD those are hard cases to win just on GERD. That's gastric reflux. Plantar fasciitis, again, that's going to affect your walking, but it's not going to affect you sitting. So again, I think that the back and knee are probably going to be stronger. If you have a good lawyer under 50, you're fine. Good lawyer is a key. To a point, I mean, look, it always helps to have a lawyer who knows what they're doing. But if you're under 50, if you're 35 years old with a mild bulging disc, I don't care who you got, you're not going to win. So I think, in my opinion, again, just me, whether you win or lose, it's about, 75, 80% of the medical record. Your lawyer is going to be about a 15% difference in terms of preparing the case, having a working theory of disability, be able to explain it, making the judge feel very comfortable. And then 5%, let's say, is your testimony. So, it can make a difference, but it is, I think, in my opinion, being a good lawyer, you win the cases you're supposed to win. You don't lose ones that, or you have a judge who decides to challenge you and as being a jerk and you push back. I've had a few cases where a judge floats the idea of changing the onset date to last Wednesday. And I'm like, no, we're not doing it. But I'm aware typically that the judges might be doing that. And I know my evidence, so I can say, no, the back injury goes back to 2019 and here's the exhibit number. And usually when you challenge them, they'll back down. And you may have to talk, I talked to my client, we may have to take a partially favorable and appeal it, but I won't necessarily consent to it if my client does not agree and if it's not supported by the evidence. Christina, always telling people not to forget to share, like, and subscribe. Yes. Last question, Dr. I think we answered that question. Primary care, not as important, and being 30 is the bigger problem, in my opinion. I'm 55 and the adjudicator had no idea the grid rule 202.06. You're definitely trying to help me. What I would do is I would go to my website, print off the light grid rules, get a red pen, circle it, and send it to her. Send it to the adjudicator and saying, here's the grid rule. I meet this. Go ahead and evaluate me under this grid rule. Make it impossible realize that most adjudicators I've talked to really want to do a good job. They're not trying to be jerks. Are there a few that are just incompetent or mean-spirited? Yeah, there's going to be a few. But they're all being, their work is being reviewed. And so if you send in a copy of the grid rules and you circle in big red, bright red ink, look at this, and they don't, they're going to have some explaining to do to their supervisor. So, if you have to go that route, you go that route. Corlil, thank you very much. I really appreciate that. Very, very nice of you. Madeline is another paralegal legal assistant in my office. Hello, Madeline. She does call screening. She'll help call people back that are reaching out to us. And then she does some substantive work with Jen to get the files ready for hearing. So good to see you on here, Madeline. And as Madeline knows, and Jen knows, if something pops up, like for example, the workers' comp issue, I will send them the blog post. I'll send them an article. Just want you to be aware of it because, the more brains involved in your case, the better. So, I want the people on my staff to know what's going on substantively and kind of what, what it takes to win a mental health case, what it takes to win a back pain case. So, I always try to educate the folks in my office about those things. And I appreciate the fact that Jen and Madeline are here because, again, a lot of the stuff I'm talking about, these are things that they deal with on a day-to-day basis. Digital hippie, my caseworker gave me the stage. Oh, okay. So you had a hearing and your caseworker or your rep basically just said, present your case without preparing you with the ALJ. That's not good. I mean, I think that, if you're a representative and you're getting paid 25% of past due benefits, you sort of have the obligation to prepare your client. Now, I've got a lot of videos out there about what happens at hearings, and I've had lawyers tell me they'll tell their clients to look at my videos, which is fine. But you may have to do your own, if you learn what to expect, what to do. But that's not cool, in my opinion, if you just show, if you have a hearing and you've been given no prep work at all. I'm sure it was nerve-wracking. Absolutely. Hey, Rodney, how are you doing? By the way, Rodney is one of our old clients, and he had sent me his hearing audio, and I converted it to MP3 for him, and I sent that to him. And the original, by the way, is sitting in it's in my office with one of the staff people there. So if you drop by, then you can get that. If you want to mail it to you, I can do that too. But it's available for you. So I left it at the office. If I'm ever going to Jeopardy, give me a history teacher. Yeah, I think you mean like what's that? What was that game show where you had the lifeline? Who Wants to Be a Millionaire? I think that's what you mean. Yeah, Jeopardy. I don't watch a lot of TV, but I've watched it, and there are certain categories where I know I'm answering the questions. I know them. Some of the stuff I don't know. If you're asking me about TV shows in the 80s of the 2000s, I'm not going to know. But if you're asking me about history, I have this mind that I kind of obscure, irrelevant facts for some reason stick with me. Sometimes the grocery list doesn't, but obscure, ridiculous facts do. So I will probably be pretty good on those shows. Although I'm guessing they're probably pretty nerve-wracking to be on a game show like that where you have to move very quickly. But I'm usually able to get a lot of those questions. St. Louis, you mentioned I worked in problems with authority. Please talk more about making the case. It was specifically. Okay, so what I was talking about before is I have a client, and the medical record said that this individual becomes very antagonistic and disrespectful to supervisors, has a very quick temper. One of the issues in working, a characteristic you need to have when you work is to be able to get along or interact appropriately, is maybe the best way to put it, with coworkers, supervisors, or the general public. And some jobs, you might have a job where you cannot interact with the general public, but you're okay with coworkers and supervisors. Other jobs, you have very difficult time with any of them. So I think that, if that is the case, you need to have evidence to that effect. And that could come from your psychologist, psychiatrist. It could be a statement from a former coworker or supervisor saying that, St. Louis, or Lewis, I'll call him, let's say his name is Lewis, that Lewis, was a diligent worker, tried to work very hard, but if his work was questioned, he had a tendency to just blow up and be very, very angry and curse and storm off. And, this is a consistent problem of, not taking criticism well, or not, or getting into fights with coworkers. And it sounds silly, but sometimes a symptom of depression. I've had, I had one time, this is going back years, I don't know, I just thought about this. There was a woman in my office who was not an employee, but we were sharing space. And so we gave her, my partner at the time and I gave her a free office if she would agree to answer our phones, and we weren't that busy, so it was a nice arrangement. Well, for some reason, I reminded her of her ex-husband, Leonard. And so she had this thing where she just early on took a dislike to me because I reminded her of Leonard. I kept telling her, I'm not freaking Leonard, just, but she couldn't get past it. I guess I sounded like Leonard. And I guess Leonard was a really good looking guy. It must have been the deal. But anyway, I reminded her of Leonard. So finally we had to just say, look, this is not working. You need to move on. But that's an example of a person who, and I've had other people that, male, perhaps there was some sexual abuse or something, and they cannot deal with male authority figures, and it's in the record. So, for whatever, and the case with Leonard is kind of silly because that was a one-off. But let's say that you have a survivor of sexual abuse, and that person cannot take instructions from a male, or a male with a dark voice, or a male with facial hair. That's the sort of thing where that can reduce the number of potential jobs out there. And I've had judges put that in hypotheticals. Now, is that going to win most cases? Probably not, but it might, what they call, erode the job base. You may have fewer jobs that could potentially be available because, you cannot have any male, supervisors or coworkers in your immediate vicinity. And that may eliminate, a third of the jobs or half the jobs. May not eliminate all of them, but that in combination with something else might be enough to win your case. So, but I think you need to have evidence from a psychologist talking about those things. Melinda Damon, hello from Massachusetts. Hello, Melinda. I'm assuming it is getting a little chilly up there. We've actually in Atlanta, we had a few days it was chilly, and now it's like 75 degrees again. So who knows? Steve was medieval European history. Yeah, that's again, not, you ended up doing, I think, I forget you said you did some sort of, was it IT work? But yeah, medieval European history, there's not a lot of jobs you can do with that other than teach or really go to law school, but it does teach you some good things about thinking. So I hope you find it interesting. And if you're like me, even though, I don't really keep up with, British history so much, every once in a while, I'll read something and it'll talk about, Prime Minister Lloyd George or something like that. I'm like, I know who that is. And, again, the bigger thing is I think it just teaches you to think. One of the things people, and I don't want to get off on a tangent here, but, when you go to law school, and I have people that, friends of mine whose, children, adult, I guess 20-year-old children, whatever, are getting ready to go to law school, and they say, well, what should I tell them? What can you do? And really, law school, I will tell you, is only good for three things, in my opinion. One is it exposes you to substantive areas like estate planning or bankruptcy or criminal law or constitutional law, so you know what's out there. Second thing it does is it teaches you how to use a law library and how to do research, because legal research, our system is based on the common law, which means it's based on precedent. So, if you have a fact pattern that's similar to another fact pattern that was decided by a court at a higher level, the court at your level is bound to stick with that. The Social Security world is administrative, so it's not judicial, but Social Security has something called rulings. And the rulings are where they have made determinations, usually based on a court case, about how they are to interpret certain parts of the law, Social Security law. So it really is like precedent. So when, we have a situation like we talked about the appeals council that, under the rulings, when a judge is looking at pain, there are certain things that he or she has to do. That's part of the law precedent, the ruling. And so if the judge doesn't do that, you can appeal it saying the judge did not follow ruling, let's say, 17-4P is a content, or the way rulings are described, the numbering system. But if you ever want to look at the rulings, just type in Social Security rulings, you can see some of these rulings, and they talk about how they're supposed to deal with fibromyalgia, how they're dealing with chronic pain, things like that. And some of it is a little subjective by the judge, but it does require them to do certain things. So, my long story short would be that when you go to law school, you learn to sort of analyze things using this precedent, the system of analysis. And then I think the third thing it does is they call it think like a lawyer. And that is to realize that things aren't always as they seem. Somebody tells you something doesn't mean it's true. Somebody, a judge makes a statement, and you've got to be able to know how much you can push back. So there's kind of an art to it, I guess you could say, how to think like a lawyer. And so in my opinion, that's what law school really does for you. And then when you get out and practice, you refine it, because you don't really learn how to practice in law school. You kind of learn what's there, and then you refine it over the years, which is why they call it a practice. You keep practicing, hopefully you'll figure it out. But what I know now from Social Security after doing it for 30 something years, a lot more than I knew in year one. And you just kind of, you do this enough times and you start to get a sense of what kind of cases are going to win, and what judges are looking for, and how to approach a judge, and how to not be intimidated by a judge. I remember when I started, there was one judge in particular who later on I became kind of friendly with, nice guy, but he was just, he wanted to show who's boss, and he was, very condescending and rude and so forth. And over time I realized you got to push back, and all of a sudden you push back, and whoa, he stopped doing that. And later on, we talked about it. He's just like, well, I just need to make sure that lawyers prepared. I don't like unprepared lawyers. And he decided that new lawyers were inherently unprepared, and he was just a jerk to me at the time, and to them. I don't think that's the appropriate way to do it, but that's what this judge did. But you understood it, and so down the road I would face other judges. Even more recently, I've never been in front of before, and they are, trying to throw their weight around. I'm like, I know what I'm doing here, so don't mess with me. I'm going to be polite, but I'm not going to let you bully me. And that's kind of what you learn. Okay, that was a lot of blabbing about a very simple concept, but anyway. William Blackburn. Let's see, is it going to assist with education loans? Okay, so you have individual loans to match. Yes, there is a, let me see if I can find it for you. Discharge, disability discharge, student loans. Okay, so there is there's a website you can go to, and let me just put this in the comments here. It's called Disability Discharge, where if you have a finding of total disability, you can go to this site and you can ask for a discharge of your student loans based on disability. And if it's a private loan, it's going to be more difficult. But if it's a public loan, or government loan, Department of Education loan, you can do that. So that's where you would go. I will also tell you, and I used to do bankruptcy work for many years, and part of that I did a little student loan discharge work. There is, at least right now, there's been a lot of activity on, discharging student loans based on an income-based repayment. And I believe Social Security disability does not count towards that. So you could theoretically get a repayment plan of $0 per month. So you might want to look at that as well. I will tell you from experience, the student loan discharge world is very, very disorganized and convoluted, because there's all these programs going in and out of existence. They're very hard to understand. There are lawyers who do student loan work, and because I used to do some of them, but I kind of just got to the point where it was not something I really wanted to do. But if you type in student loan discharge lawyer, you should be able to find somebody who understands how to do an income-based, program for repayment of student loans that would put you at zero, and or do a total and permanent discharge based on disability. So that's how I would handle that. At least that's what I would do as far as the starting point to look around. Rusty gun sounds like that is not a good thing to have, because that could you get, what do they call it? Tetanus from a rusty gun. Denied a second time, told I could drive for Lyft or Uber. I'm 59 with the griddles and not waiting for a judge hearing. Okay, so you've been denied at initial and recon. And realize at the initial stage of application, about 35% of applications are approved, but those are typically listing level condition. They're very, very serious. You cannot walk. You have your heart's pumping at 20%. I mean, really, really serious. You don't need to be that bad off to win disability. Recon goes back to the same people. It's got about a 15, 17% approval rate of people that appeal. Very, very low, the lowest other than appeals council. Now you're going for a hearing. Get in front of a judge, you got a 50% chance on average. And you're 59, so the grids probably very likely apply. It's possible the adjudicators did not understand how to apply them, or they were not comfortable making decisions about transferability of skills. But I would tell you, anybody who's over 55, I think, I haven't seen statistics, but I'm guessing that the approval rates for people over 55 has got to be in the 65 or 70% range. So I think that you want to keep at it. And if you've got an attorney, get in front of a judge and make a grid rule argument, assuming you've got physical limitations. But again, going back to Rusty's point, just because initial and recon, the state agency denied you, don't give up, because they deny everybody. Every hearing I try has been turned down twice. And they deny many deserving cases. Okay, so the SS a good side on approval rates is up to date. Not as easy to use, but let's see if I can find that for you. SSD judge approval rate. So yes, there is a site here, and let's just share the screen so you can see it. I use this sometimes, but not that often. Here is the screen. Here is it. Here's that. I'll put the link in the comments here. So yeah, there is a table here you can download. You could do a search on it too. I think, it doesn't give you percentages, but you can sort by different things on the table here, and you can download it until, to XML, which isn't going to help you very much. I don't know if you can download it to a spreadsheet, but you could certainly do a search. So let's say that I'll just do a quick search. Let's see, Control F. He's not there anymore. Okay, so I just did a search on Jackson. There are 20, first or last name Jacksons. So I can go through and I can find, different, some of it's based on the city, but, Karen Jackson is a judge, and you can see, and you have to be able to do a little math and figure out what the columns are. It's just not as easy to work with as the Atticus site, but this is more up to date. So I'll grant you that. Okay. Benzo is at step 3. The medical record, still nothing. I think I mentioned this. I don't put a lot of weight into step 1 or 2 or 3. It's going to take an initial. It's going to take 10 months, 11 months. Recon, 8, 9, 10 months. Hearing is going to take 6 or 7 months. But step 3 is just something they're telling you. I don't think it means a damn thing, personally. Brandon, you are welcome. Terry's RFC, unscheduled breaks. Yeah, all these things would, uncontrolled diabetes, all these things would be work preclusive. So you've got to get the judge to accept that. And not only does it need to be on the FCE form, but it needs to be in the treatment records. So realize if let's say you go to the doctor, about your diabetes, and the doctor doesn't say anything in the treatment records about, unscheduled breaks or being on your feet or not having your legs, bent or whatever. And all of a sudden in the functional capacity form, it's in there. A judge might look at that and say, where did this come from? So it needs to be in both the medical record and the form. Nicole Thigpen, can you represent some of an ALJ hearing? I will look at denials. I tell people send them to me. I will look at them. I'll have another colleague of mine look at them. And I have taken a few of those cases. I mean, the AC and the federal court are pretty, it's hard to, you have to have a clear error. And so I would say of the ALJ denials from other lawyers that I look at, I may take 10% of them. But if you'd like to send it to me, I'm happy to look at it. Obviously, there's a 60-day deadline, so there's not a lot of time, but I'm happy to look at it. Your existing lawyer would need to waive fees. But again, the first step would be just for me to look at it. if you're not comfortable with having your lawyer do it. And then I would tell you if I think there's something there. Golfer Pro 12. Okay. Can you go on vacation? At the appeals council, they're not going to ask that. If it gets remanded back to the ALJ, then, I've had judges ask people, what's the furthest you've taken a vacation on the last year? Did you drive? Did you fly? What did you do? It doesn't eliminate the chance of getting approved, but, your handle here is Golfer Pro 12. Would I go out and play, several rounds of golf? No, if you've got a problem that's physical. So I think you just have to, and by the way, if you have social media like Facebook or Instagram, put them on private. You never know if a judge is going to look at that. So no, you can go on vacation, but you maybe ask what you did. And so, if you are on vacation and you're basically sitting in a hotel or in a condo and, go out once a day and you're with your family, not really a problem, but you might want to have a statement from a family member saying that's all you did. But if you're going out and playing, 18 holes every day, that's more of a problem. But they would ask you what you did. So you're not disallowed going on vacation, but you maybe ask what you did. All right, Deb is asking about the brain tumor. I think Deb always has some good ideas about how to proceed, which I appreciate. I think he said it was benign, which again doesn't mean it's not pressing on something, but I don't know that 11.05 would apply to benign tumors. But, again, it would have to cause some significant functional deficits. Hey, Tara, how are you doing? Good to see you today. Maria has L4, S1 laminectomy surgery, carpal tunnel on the right hand, left hand. She said an SSDI case has been denied 3 times by an administrative law judge. Yeah, I think that you don't say how old you are, but being denied an initial and recon doesn't really tell me that you don't have a good case, because they deny people all the time. And especially with back pain cases, because the standard they look for is so way up here, whereas a judge is only going to look down here. But if you've got post laminectomy, if it did not work well and you've got carpal tunnel, you can't really use your hands for work. And if you've got severe back pain, you got to stand up and move around or lie down, lie in a recliner. That would be, if you're over 50, and you've got symptoms, I think you've got a pretty good case. Dahlia Yusuf. Oh, my pleasure, Dahlia. Thank you for tuning in. Digital Happy, if you've been denied 3 times, you already did an LJ. Yeah, I think he's getting back to what Maria said. I think what Digital Happy is saying is, if you've been denied 3 times, it means you've already had an LJ hearing. Typically, you're denied twice, initial and recon. So maybe she just mistyped it. Okay, why does the ALJ send you to a non-specialist doctor? My health conditions are neurology, cardio, ophthalmologist, and digestive. Ask my attorney to send them all my health reports. They have an obligation to develop the record, and it doesn't make a lot of sense. And they can send you to a specialist. Many times they'll send you to a general practitioner first, and he might or she might say in his report that Ms. Yusuf needs to be seen by a gastroenterologist, an ophthalmologist. And you can certainly attack the weight, the credibility of that physical capacity evaluation by a physical internal medicine doctor by saying he doesn't have the training to know how to diagnose me properly. So I think your question was, is it a bad sign? No, not a bad sign. It just means they're sending you to one of their doctors. If you have your own medical records from your specialist, that's going to be a lot more important to most judges. Hello, I think Tara is saying hello to Jen. And Digital Hippie said that they sent his case to a neurologist. That's pretty much on track there. Makes sense. All right, Maria's got a hearing on the 19th of November. So it's coming up. let me go back to see what we were talking about. Again, you didn't say how old you are, but your symptoms, the laminectomy, post-laminectomy, assuming that it's did not solve the problem, and carpal tunnel, I think you want to really focus on the functional limitations. The carpal tunnel. You don't win because you have a carpal tunnel. You win because you cannot use your hands bilaterally for lifting more than 2 or 3 pounds. That's going to eliminate a huge swath of jobs. You have post-laminectomy syndrome, and you can only sit for 10 or 15 minutes. You've got to take a 15-minute break every 30 minutes. That's going to prevent you from being a reliable employee. So it's really the practical implications of your medical problems that win you your case. Okay, free case evaluation. I think I've got that there. So St. Louis Grant had asked me about the difficulty with authority, and so Deb brings up a good point. There is a diagnosis in the DSM-4, 5, 6 of oppositional defiant disorder. That's pretty extreme. I don't think you need to have it at that level, but that is the technical term for a person who just cannot get along with others. Marie is an industrial painter, retrofitting bridges. Again, you got to tell me how old you are. Tell me whether you can use the grids, because you could definitely argue the grids if you're over 50. And I suspect almost certainly that you would have no transferable skills from being an industrial painter. So I think the grids, if you're over 50, would most definitely apply. Kay Wolf says, best. Oh, we all wish Maria the best of luck. It's stressful to go to hearings. I think Maria said what's out here. No accidents for reparative work, our position. Yeah. There's not going to be transferable skills to something lighter. Candy Tap has several issues cause making it hard to work. Could I list all of them? Yes, you can. Certainly. I'll give you my opinion. But again, you don't win based on a diagnosis. So it's not just the diagnoses or the issues. It's I have headaches. That's the problem. But I have them 4 times a week that last up to 2 hours at a time. When I'm having a bad headache, I cannot focus and concentrate. Need to be in a dark room. I have a bulging disc that presses on my spinal cord and causes radiating pain where I cannot sit in an office type of chair for more than 10 or 15 minutes. And I've got to stand up. I've got to be in a recliner, 30 to 40 minutes every 2 hours. So it's the practical side of it, not just the diagnosis. Okay, Maria's from the Bay Area, worked in the San Mateo Bridge, Golden Gate Bridge. Wow, so you've seen your share of bridges. That's very interesting kind of work, and I'm guessing it's pretty dangerous too. But wow, so I was not aware that there was a industrial paint job for bridge painters. All right, Maria's only 46. Okay, well, disability for Social Security it's all or nothing. It's either you are disabled or you're not. Doesn't mean when you say permanent disability, doesn't mean you would be on disability the rest of your life. It just means that you've got to be. It's not like in the VA where you can be, 30% disabled. Yeah, this is like you have to be disabled at 46. The grids will not apply. At 46, you've got to show that because of the back issues and the carpal tunnel, there is no work at all you could do. And literally, I mean by that, imagine I said to you, here is a job. You're, sitting in an air-conditioned warehouse, putting ink pens in a box, or you're monitoring security cameras, or you're, marking labels at a laundry. Again, with carpal tunnel, that's going to be hard. But there are jobs, inspection jobs, that you could do without really using your hands very much. So assuming that there is a simple sit-down inspection job that requires minimal or only very occasional use of the hands, we'll call it incidental use of the hands, are there jobs out there? And there probably would be, but then you add to that the back pain from the chronic back pain from the laminectomy, that didn't work all that well, then you've got a winning case, even at 46. Why been in a 59 when the grid rules in place now? Well, again, Rusty, it looks like you were denied an initial or recon by the adjudicator. And some adjudicators don't understand how the grids work. Others understand how they work, but they're not prepared to make a determination about transferable skills. And so, a lot of cases that should be approved at initial recon end up before a judge. And I know because a lot of my cases are like that. I would say, I do pre-hearing briefs in almost all my cases. I reference the grid rule probably 80% of the time. So I think there's a lot of people out there who meet a grid rule, but the state agency adjudicators aren't gonna find that. And Garrett's putting on here, this is how you get sample residual functional capacity forms there. Will Trump be able to cut just a bit? I don't think so. I think that the disability percentages are set in the law. If a president was determined to reduce the expenditure because of disability, they could fundamentally change the program. But again, as I've mentioned at the outset, a lot of the people that voted for him are people kind of in that sweet spot to pursue disability. Is he going to want to piss them off? That's the question. Let's see here. Okay, residual functional form. Okay, so this is another website. Another gentleman has put these available out there for everybody for free. Ben Adams. Wow. Thank you, Ben. 20 bucks. Hey, that's really, really nice. I really, really appreciate that. I think as I mentioned to you, I use this, I'll buy staff lunch, or I'll, take my son out to lunch, or my daughter, whatever. And, obviously it's the gesture, which I really appreciate, but thank you. That was very, 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 very nice of you. How likely is an ALJ to order a C exam before, during, or after a hearing? I don't see it as much before a hearing. They're not going to order it during the hearing, but afterwards, I would say 10% of the time the judge will keep the record open. He or she will say something like, Mr. Ginsberg, I think we need to have a consultative here because there's not enough evidence about your client's foot or whatever it may be, or heart. So they will do that sometimes, but not that often. I do the same fee. What are my rates? I do the same fee that everybody does. It's 25% of past due benefits. I use the official Social Security contract, and I don't make my own. It's their contract that we do. So it's no fee unless you win. 25% of past due benefits, any benefits that have accrued, since the onset date, absent the 5-month waiting period, and it's capped. The cap right now is $7,200. It will go to $9,200, assuming that's not changed, and that could change. But right now, it's going to go to $9,200 at the 1st of December. But it's no fee up front, 25% of past due benefits. Let's see here. Digital Hippie says, I didn't have a CE and the ALJ required a CE review. My rep had it sent to the neurologist. So I'm not sure if you're saying that the judge sent you to a neurologist and you sent some of the other records to that neurologist. Maybe that's what you're saying. But yes, sometimes a judge will send somebody out for a post-hearing CE. Okay. It would take all my... No, you're not allowed. Any fee that you charge has to be approved by Social Security. So the fee contract, and I'll show it to you. I mean, I'll show you the fee contract that I use. I'm not ashamed to do so. So let's go over here. Just let me make that a little smaller. Share my screen. And I would say most attorneys who do this are going to have, so you've got a couple pages of instructions here. All right, this is form 1693, by the way. And it says here, I have an ID, I have a rep ID, got to put that in there, my name, client's social security number, all that stuff. And there's standard, it says, if SSA favorably decides my claim and the decision results in past due or retroactive benefits, I agree to pay my rep a fee that does not exceed the lower of 25% of past due benefits or the maximum dollar amount allowed by Social Security. And $7,200 as of November 30th of 22. This is going to change at the end of this month. They're going to make it $9,200 as of November 30th, 2024. You can also do a flat fee or a lower percentage. And you can also, and some of this is not really well worded, but you can it also says that the attorney has the right to file a fee petition, which very few people want to do because it takes forever. You can do something called a two-tiered fee agreement that basically says that if the ALJ decides my claim above the hearing level, let's say, the fee agreement is void and my representative may seek a higher fee by filing a fee petition, which you can do anyway. And or you can summon us, the attorney will set an escrow account, or some other party is paying it. You can read all this on your own. Just type in SSA 1693. But typically the one I choose is this one here, where I agree to the maximum fee as stated by the commissioner, which is 25% of past due benefits capped, and that's what I use. This is their official form. So I don't even. I used to use my own, but I don't do it anymore. And it's not particularly well written. I've been tempted to redo my own, but the problem is judges see something that's not from Social Security, and I've had a couple of times the judge will deny my fee agreement because of some ridiculous reason, and I can't get paid. So I just figure I'm going to use their agreement, and that tends to work. They're going to actually change it. One thing they're going to change is, up until now, Social Security has only allowed individuals to represent people, not law firms. And they're going to change that where you can have a law firm with multiple reps do it, which, doesn't really affect me because it's just me doing the hearings. But if I have somebody else, if I had another associate, like I've got another attorney at my office that works with me, and sometimes she will do a hearing for me if I've got it double booked. And so it's a real pain. I've got to withdraw and waive fees, and she's got to file her own fee agreement. This would make that a little bit easier. But that's one of the things that Commissioner O'Malley has done. But they cannot take all of your past due benefits. They can only take 25% that is capped. If they could file a fee petition, but they're not going to get approved for a lot more than that. Thank you, Christina. I appreciate you reminding people. I won't put the wrong place here. This is where you would put, you could leave a review. I've had several people do it, and I really appreciate that. That's great. Yeah, it used to be 6,000, now it's 7,200. It's going to go up again. Okay. Well, actually, that's not true. Doesn't depend on when you started the app. It's when the case is decided. So if somebody, if you retain an attorney in November of 24 and your case is decided in June of 25, the higher fee will apply. It's not based on when you were retained. It's based on the current maximum fee from Social Security. So you started 2 years ago, if you started and the maximum fee was $6,000, now it's $7,200, you could, you got approved before the end of November, you get the $7,200. If you get approved in January, it could be $9,200. So just be aware of that. It does take a while. That is an understatement of the year. Okay, let's see what else we got going on here. Maria says, I'm trying to see a neurologist. My surgery, a problem with my bowel issue still in your... Yeah, those are really powerful, significant problems. So I definitely would make sure that your lawyer is aware of that and that you've got the evidence there. And I mentioned the 5-day rule. If you have your hearing on the 19th, I would tell you, I don't think there's any holidays during the week, but no later than the 12th, let's say the 11th or 12th, let's just to be safe, say the 11th of November, your lawyer or rep needs to send a letter to the judge saying the following records are not yet in the file. We're trying to get them, and here's what we're doing to try to get them. That's called a 5-day letter. But you don't want to go into your hearing with things not in the record that are available, because your judge might not agree to accept it. Digital Hippie had his hearing on October 22nd. Okay. Get those problems documents. Yes, that is correct. $9,200 at the end of the month. Let me just comment on that. And again, I'm not going to. I'll just give you my opinion. They left it at $6,000 for like 15 years, and we were not getting cost of living. And quite frankly, a lot of lawyers that did this got out of it because you're looking at 2 to 3 years of work. Um, and realize most of the time you're not getting the full fee because either the amendment, the onset date gets changed, or the amount of the benefit is not that high. So I will tell you, my practice, it's $4,000, $4,500 is my average fee. Again, I'm not complaining. This is what I signed up for. Sometimes I get $7,200. And they actually charge a user fee, so it's never quite that much. It's going to be $7,000 approximately, $7,083 to be specific. So, the fees are capped. What that does, I will tell you, is a couple of things. One is that it forces lawyers like me to only take cases where there's a high chance of approval, because you don't want to take a case where you're going to work for 2 to 3 years and not get paid. So it makes it hard for people with more difficult cases. The 35-year-old with severe depression, he or she is going to have a really hard time finding a lawyer because there's no benefit, to taking a case that's got a low chance of approval. If they paid, let's say that you were allowed to charge, 30% or 20, I don't know, 35% on a case that's more marginal for a younger person, you might find lawyers willing to do it, or if they didn't have a cap on those cases. But by limiting the fees, they're basically telling lawyers, you only want to take good cases. There's a real chance of winning. A lot of people who have legitimate cases, but they're young, they can't get a lawyer. That's because it's just the risk is not worth the reward, and that's one of the problems with it. And so when it was at $6,000, you look at it and say, well, that's not a lot of money after 15 years. That the cost of things have gone up, so you got to be really, really selective. Raise it to 72, I can take more of a chance. Raise it to 92, I can take even more of a chance. So it allows lawyers like me to take on cases that are a little more iffy. And I think that's not necessarily a bad thing. And like I said, the cost of doing business, I mean, again, I chose this and not complaining about it, but, employees want to get paid, understandably so, and salaries go up. We've got, malpractice insurance that goes up, property insurance, everything goes up, copier fees, copier costs go up, computer costs. I mean, everything goes up. So, they have to at least make this in line with the cost of living, because otherwise you get to a point where, either you're so selective that it's not worth doing, or you just stop doing it. So, there have been good people that got out of this practice area because of that very reason. You were scared to go rusty where? To a doctor or to the judge? What state you start application all motor? And again, some states are slower than others. And he started in Utah, moved to California 12 months ago. Okay. LJ from California. Again, some good, some not so good. Tommy says, I'm planning on requesting cover my file from SSA. If initial app gets denied, I don't know what best time would be. Want to be prepared for going to appeal the 6th. Yeah, I mean, I would tell you, as soon as you get the denial notice, see if you can get a copy of that file. You may have to go down to the Social Security office and see if they'll burn you a CD with the medical evidence, so you can sort of see what they've got. Now, I will tell you that as an attorney, I have access to my clients' electronic folders at before the case is even decided, within a couple of weeks of filing, and I can see on on both. I can download the records, or I can see on a printout what they have. So it's available. It's just a matter of getting it. And if you're not represented yet, Social Security office will be able to get it to you. Calvin, Florida. Florida is the worst. Florida and Texas. Florida is like, way, way behind. I don't know why, but they're just way, way behind. I had to talk to my client, got a hearing coming in a couple of days, talking to her today, and she was complaining about how bad Georgia is. And yeah, she happens to be in Georgia. I said, I said, Florida and Texas, way worse than Georgia. She was still not happy, but okay. Only if you are if he is deceased, I believe. I don't think you can do it if he's still alive. I'm sure with an ex-husband you probably wouldn't mind, but I think he's got to be deceased. How long? It just depends on how busy they are. I would probably make an appointment and just go pick it up. Oh, and here's somebody that said they sent my copy by email the same day. That could happen too. Yeah. Okay. So that's digital hippies experience. And I've had people. Sometimes I'll say, "Get me the file," and they'll have it emailed to them that day. So that is true. Can happen. I've seen it happen. Angie says, psych evaluation 1126. I think that the main thing I would tell you, I've got a video on this. If you look at my video channel, you want to make sure you give it your best effort. There are tests that they do to check for what they call malingering or secondary gains. So, they'll say, spell the word world forwards and backwards, as an example. And so, but they may ask you some other question, that's related to that. And if you give one answer one way and the other way, they'll use that against you. So I would just say you want to give it your best effort. If you've got, they're going to ask you about your history and how your mental health issues arose. Don't exaggerate. Don't look like you're trying, just be as truthful as you possibly can. And, usually the psych CEs are pretty decent because these are practicing psychologists. So don't try to overthink it, is my point. Don't try to overthink it. Okay, I got somebody else who left me. I'm not sure who that was. Boris, $10 basically. Thank you, Boris. I really appreciate that. Very, very nice of you. That was very generous. I really, thank you. Okay, we got a few more minutes here. Cindy with a YG. I'm past 55 with the grid rule. Living in another country with an acceptable list to receive SSDI, a rare disease. Many doctors ever document nothing more than do so. This is a problem. This is definitely a problem. You have doctors in another country who may not be familiar with what Social Security wants. Sometimes I'll tell people, go to your own doctor. Take a copy of the grid rules with you. You have to educate them a little bit about the fact that Social Security is looking at work capacity issues. So yeah, it could be a problem. Could be. Absolutely. I've had cases for I had a client in Vietnam, really nice guy. We had a really interesting conversation. Won the case. It was interesting because the hearing was at 8:00 in the morning my time, 8:00 at night his time. He got approved. But yeah, getting foreign medical records into the record, if you have to get them translated, it can be a bit of a problem. Definitely a bit of a problem. Rusty Madeline will be talking to you tomorrow. Okay, great. Let's see. Very good question, Rusty. Should I be telling my doctors and specialists I've applied for disability? That's kind of a judgment call. I mean, if you decide you're going to do that, you want to basically say to them, I made the decision to apply for disability. It's the last thing I really want to be doing, but I have no choice at this point. But my goal is to get back to work. I think many doctors are very, very cynical and just really very concerned about people who are applying for disability because it looks like they've given up. So you have to go overboard and explain to the doctor that you have not. If you don't think the doctor will be receptive for that, I wouldn't necessarily say anything. They may find out anyway because they'll get records requests. But if you do talk to your doctor, make sure you make it clear you're not giving up and you see this as something that's not going to be forever. All right, Dahlia, why the LJ send you to, I think we've already answered that about the specialist there. Let's see what else we got going on here. Okay. Trish is always here. How are you doing? Shannon. Oh, Shannon is from, what did you say, Budapest, I think. Doctors don't have to take notes. They do as far as Hungarian data, so we'll find translation. What I've done is I've had situations where I've got records that are in a different language, I think Social Security has an obligation to have somebody translate it. I'll just tell my client, get this translated. It may cost you, 15, $20. Go on Fiverr and get it translated, and then provide a copy of the translation when you submit the record. And you may have to, basically have a statement that says this is accurate. But I think you could do that. And there probably are even translators who do so under, some sort of a seal that would, verify their authenticity. But yeah, if you have to do it yourself, do it yourself. Cindy says this is in English here, so that's not a problem there. Okay. All right, Tangi, give me a smile there. All right, Paul, I know we have the emojis are coming out. Okay. Okay, so I referred you to Lindsay. Okay, great. Yeah, Osterhout. Carl, I do a lot of work with Carl Osterhout, Lindsay's husband, and Carl is an appellate specialist. So many times we have situations where I want somebody to review an appeal, and Carl will do it. And Lindsay is his wife. Like I practice with my wife, Carl and Lindsay work together, and I've referred cases to them. I still refer cases to their firm if it's something I just am too busy. But yeah, they do great. They're really, really good people. They have some really smart people in their firm, and even though we're not formally affiliated, I feel very comfortable. Those are just people you can call up and bounce ideas off of, and they do a really good job. They've got some really, really smart people up there, and I enjoy working with them. And it's been great to get to know them all. Actually, I met Carl in person in a convention here, and then Lindsay and I have done a few continuing education programs together. So I'm glad you had a good experience with her. Okay. Yeah, you're 64. You're not going to have another CDR. This story is funny, not at the same time. Okay. Is it hard to win a cessation case after 24 years receiving? I think it would be tough for Social Security to prove that you're no longer disabled, is what I think. Okay. Rusty, I have this thing where I can instantly detect an attitude that makes me defensive. Okay. And again, that may be, you probably need to get some sort of a diagnosis on that. What is that, hypervigilance? There's something going on, because it's got to be diagnosed so that you can say this would apply in a more general sense. Well, thank you. I can be smart. Appreciate the review. Patrick Kelly. Okay. Thank you, Patrick. I appreciate that. Okay. We've got a few more questions down there. There is a YouTube video where a judge and a lawyer punching it. Okay, I've never seen that one. Now that sounds like a bit much, but that'd be interesting to see that one. I'm guessing it's kind of a spoof, but who knows? By the way, if you have not seen it, Google John Oliver, or go to my blog, ssa.gov. I'm sorry, ssdanswers.gov, ssdanswers.com, and go to my blog, and you see I've linked to the John Oliver rant about Social Security. If you want to see something funny, but it'll kind of make you shake your head, check this out. It's really, really funny. It's very, very interesting. Okay. We're now kind of at our time here. Okay, this is a very good way to end it on. Feed Monster says, I won my disability without question due to the significant records and problems, but now that the date last insured has passed. You're grandfathered in. So if your date last insured was, let's say October 31 of 2024, and you were found disabled as of October 30th of 2024, you're grandfathered in indefinitely until they decide. And then I think they even suspend the rolling of that period. But you're fine. What you don't want is to be found disabled after your date last insured. But if you've already been found disabled and you were insured at that time, it remains your grandfathered in. Okay. I think we're going to go ahead and end it now. There are a couple more questions here. I'll answer a couple more here, but King's daughter, can it affect your medical records in the document? I've asked you questions that they haven't. It shows they've recorded. I think that I've talked about this in previous live streams. If you have a consultative evaluation and the report has stuff in there that was not true, I would write down all the things that are not true, give it to your lawyer, and have your lawyer include that, make a statement out of it, maybe using SSA 795 as the form, and then in the pre-hearing brief, basically attack the consultative report saying it's inaccurate, not truthful. That's how you deal with that, because it does happen. Okay, that's talking about the defiant issue the St. Louis Grand Jury asked about before. Okay, let's go ahead and stop it here. It has now been 2 hours, which is kind of what I typically do for a live stream. I will look at getting Dr. Dave on. Somebody asked that early on about having him appear as a guest. And I was actually going to try to get, I've had Carl on before. There's a couple other people. Maybe I'll try to get an appellate person on too. But so we'll try to get some interesting guests on. You can pose questions to them. But for now, we'll leave it here. Thank you all very much for your tuning in, for your attention. Remember, if you have a case evaluation, just visit me, bit.ly/contact Jonathan3 or go to ssdanswers.com. You can fill out the form there. And if I can review a case for you, happy to do so. So for now, this is Jonathan. I'm signing out. I hope everybody has a great weekend. Stay warm out there, and we'll see you next Wednesday. Take care.